Thank you very much. I feel very welcome and very to be here at Reed College. And I really want to appreciate being invited to this very prestigious lecture cycle. I am humbled by the list of people who are have preceded me and who are going to follow. But I am particularly grateful for the opportunity to share with all of you what we are trying to do from the United Nations in the area of abolition of torture. I should say that my mandate as the special rapporteur comes up for renewal in less than 2 years. So there's hope, Darius. You can still apply.
You know it.
If you're still interested, now that you know that it's a completely volunteer thing, but I think you do great. So I would really encourage you to apply. The process of selection now is very open and democratic, as I said today at lunch. It also encourages self-nomination. So I really think it would be a great idea. But I want to talk to you about abolition of torture, and of course I mean abolition in practice. I don't mean abolition in law, because we do have a legal abolition of torture at least since 1945, since the creation of the United Nations and from the development of modern international human rights law. In fact, I have some the good news about this is that the consensus for the prohibition, the absolute and categorical prohibition of torture and of cruel, inhuman, and degrading treatment and punishment, knows no relativization, no opinion against it in international relations or in international law today. And I think the development of international law with regards to torture has had in mind the practical, the effective abolition of torture all along. It not only appears in the Universal Declaration of Human Rights of 1948, but also in the International Covenant on Civil and Political Rights of the 1960s. But at some point, the international community decided that that was not enough, that to have torture prohibited in general international human rights law instruments was not enough, and that there was a need for more specific and more focused normative developments relating to torture. And so in 1975, the General Assembly passed a resolution that even today is cited frequently for the proposition that torture violates not only customary international law principles, but also norms that have a special standing in international law that we sometimes call jus cogens, which means that it's an imperative norm that doesn't depend on countries accepting it, that applies perpetually, that does not recognize its substitution for an emerging norm either in treaty or in custom, and that all countries that aspire to be part of the international community must respect. In addition to that General Assembly resolution, in the 1980s, the international community established the Special Rapporteurship on Torture, the office that I now occupy. And it's one of the more long-standing of the special procedures, preceded only, I think, by the Working Group on Disappearances that's still in effect, and that is the inaugural special procedure, now joined by something like 50 other special procedures. But to give you a sense, one of the early ones was the Special Rapporteurship on Torture. And then almost immediately thereafter, the international community enacted, and then many states signed and ratified the Convention Against Torture. The United Nations Convention Against Torture is the instrument that we apply today. More recently, in 1987, the convention actually creates also a committee, an organ, a treaty organ that is in charge of monitoring the observance of the prohibition on torture and all the other legal effects that I'm going to discuss with you later on that are included in the Convention Against Torture. More recently, the international community enacted an optional protocol to the Convention Against Torture that is designed to prevent torture from happening in the first place. And that optional protocol actually creates a separate treaty body called the Subcommittee on the Prevention of Torture that visits detention centers all around the world with the intent of preventing torture from happening. And as you probably know, torture has been always considered an international crime, meaning that all countries are supposed to suppress it and to prevent it and to punish it when it happens. So it triggers both the jurisdiction of international courts like the International Criminal Court, but also the possibility of using universal jurisdiction, that is, countries that open up their own courts to deal with torture that may have happened in other territories and against victims that are non-nationals and by perpetrators who are non-nationals. So torture has a special place in the canon of international human rights because, as Professor Antonio Cassese, the late Italian professor who was the first Chief Justice of the International Tribunal for the former Yugoslavia, has said, torture is unique because it's the only violation of international law that triggers the obligation to investigate, prosecute, and punish it, even when it is an isolated incident. Now, when he wrote that, that was obviously true. Lately, the Convention Against Disappearances also incorporates the same principle. So nowadays, neither disappearances nor torture have to be part and parcel of a pattern of deliberate or widespread violations in order to trigger this obligation to investigate, prosecute, and punish, and even to trigger universal jurisdiction or the jurisdiction of international tribunals. So if we have a highly developed normative framework, and if we have some mechanisms of implementation, like my rapporteurship, the Committee Against Torture, the Subcommittee on the Prevention of Torture, and several regional bodies also dealing with this, and we have some institutions like the International Criminal Court that has jurisdiction to punish perpetrators of torture, how come we cannot claim that torture has been abolished in our lifetime? And of course the news are not good. The state of the question of abolition is pretty dire. Amnesty International, for example, has launched a new campaign. I think it's a third campaign that Amnesty has launched on the abolition of torture, beginning with one in 1970 and another one a few years later. And the first thing that Amnesty says is that torture is practiced in one degree or another and with different degrees of severity in something like 142 countries around the world. And what's even more depressing is that the figure is more or less the same as Amnesty said back in 1970 and later on in the early 1980s. So there is no reason to be optimistic about being able to abolish torture in practice like once the international community abolished slavery in our time. But I think it is still possible, and perhaps it's not going to be in my lifetime, but hopefully in the lifetime of my grandchildren, that we will see a situation in which torture becomes not exactly a thing of the past, but at least such an exceptional phenomenon that it's easy and effective to deal with as an anomaly rather than as a regular practice. But we do also have in the recent history some reasons to be optimistic, because even though torture continues to be practiced in many countries, it's not always the same. We have seen countries that have made transitions from conflict to peace or from dictatorship to democracy, and there we have seen torture diminish. We have seen the ability of state institutions to deal with torture, even with torture in the recent past, but also with torture in the present, more effectively when we recover institutions and we recover democracy, and we have an open society that doesn't tolerate torture and effectively, prohibits it. But even in those cases, unfortunately, there is a persistence of the low-profile mistreatment against, for example, common crime offenders or against members of marginalized and powerless communities. And this torture against vulnerable people goes largely unrecognized because the general public doesn't want to think about it. They're more concerned with crime and with not tying the hands of the police to stop crime. And so, because the victims are not the high-profile political prisoners, even in very democratic countries, newly democratic countries, but clearly deserving the name of democracies, this phenomenon of the low-profile torture is really difficult to eradicate. And we have to recognize that there are no new and insidious forms of torture that we don't necessarily associate with torture. We think of torture as what happens in the interrogation room when somebody is being forced to confess or to give information on somebody else. But that's obviously part of the paradigm. But we are beginning to recognize that there are forms of pain and suffering inflicted on individuals that, although we don't necessarily associate with torture, we should. And I'm talking, for example, about solitary confinement. My first thematic report when I became the special rapporteur was dedicated to the issue of solitary confinement, because I had the sense that solitary confinement was being widely used around the world, and that it was a kind of a creeping phenomenon that appeared out of nowhere without people paying much attention to it. And solitary confinement undoubtedly has some legitimate uses. But when it's used against certain categories of prisoners, like children, for example, or like women, pregnant women, or against people with mental disabilities, it should be absolutely prohibited. And when it's used even for sane and healthy inmates, when it's used in a prolonged or indefinite fashion, it should also be prohibited, because after a certain duration, the isolation and the lack of social contact of any sort produces the kind of pain and suffering that's clearly defined in the definition of torture under the Convention, because the definition includes both physical torture but also mental torture, the pain and suffering of a mental nature. And the science is very clear that prolonged or indefinite isolation after a certain time makes the mind work differently, and sometimes the effects can be long-term. We also begin to identify some forms of torture and cruel, inhuman, and degrading treatment in healthcare practices around the world. Like, for example, non-consensual restraints or non-consensual isolation of people with mental health problems. Of course, that doesn't mean that all kind of non-consensual treatment is absolutely prohibited, like some activist groups want to get to, but the non-consensual treatment has to be limited. It has to be limited to avoid major harm to self or to others, and it cannot go beyond that. Unfortunately, in many parts of the world, a diagnosis of a mental illness is enough to take completely the agency away from the patient. And of course, that denial of agency also results in treatment that is painful, either by use of chemicals or by other kinds of restraints, and particularly, that creates a kind of pain and suffering associated with torture. But I don't mean only treatment of mental health problems. I also mean, for example, treatment of drug addiction. In many parts of the world, it is done by complete, first by detention and isolation, and complete denial of any alternative treatment. So the denial of methadone or any other alternatives to drugs, can result in the short term, especially in the kind of pain and suffering that also is associated with torture. And if it's not necessary because there are alternatives, then states don't have a right to engage in it. The same can be said, for example, about reproductive rights. States have a choice to allow abortions or not. But even in those countries where some forms or some circumstances for abortion are legally available, women are subjected to humiliating treatment when they even ask for a service, a health service that they are entitled to. And it is the responsibility of states to avoid humiliation and to avoid mistreatment. Another example of this torture in healthcare practices is denial of pain treatment. In 87% of the population of the world, there is no treatment with pain relievers. When they are easily available, and it's mostly because of a concern about addiction and about trafficking in the drugs as well. But that's not enough of a reason to subject people to painful suffering when there are alternatives to pain. I also think we recognize that although the definition in the Convention Against Torture requires that the perpetrator has to be a state agent, or that the torture has to be conducted with the acquiescence or tolerance of a state agent, there are a lot of gray areas where we now recognize that we need to hold other actors, non-state actors, responsible for torture. I mean, for example, torture perpetrated by insurgent forces or other groups not controlled by state action, but that in fact fight against states. Fortunately the laws of war, the Geneva Conventions, have very clear norms prohibiting outrages against the personal dignity of prisoners, for example, and certainly attacks on civilian population and on all non-combatants. So we have the legal instruments to deal with that. But there's also an area that we increasingly consider as the responsibility of states, which is the kind of torture and ill treatment that may happen in the domestic setting, where in domestic violence we can and we should hold responsible the state, at least for those situations in which the violence against women and against children happens in circumstances where the state knows or ought to know that the person is at risk, and even at that refuses to act or to prevent. It's very well established that domestic violence, when it reaches a level of suffering that we associate with torture, if committed by a state agent, can, under those circumstances, be attributable to the state as well. I think the main challenge that we have in this, sad scenario of so much torture still going on is that there is a weakening of the consensus to condemn torture in our in our time and in our societies. And I mean all of our countries and all our societies, and I mean particularly the culture. The culture today, the popular culture, conditions us to believe that torture is inevitable, that torture is something that has to happen even if it's ugly, and that if it happens to people that we don't know and that we don't want to even know how to pronounce their names, then we can ignore it. And we have been conditioned to believe that breaking some norms is okay. It's even cool in some settings because it makes us safe, or we believe that it makes us safe. Safe from terrorism, but also safe from common crime. In many countries around the world, the moral condemnation of torture that was once a very clear consensus that we had among all societies has been lost. Not fatally, not forever. I do believe that we can regain that moral consensus, and campaigns around this should be held. But we ought to confront the arguments that torture works, that torture, makes us safe, and that we don't pay a price, a political, moral, or even institutional price for letting our state agents engage in torture. We have all the evidence to show that torture not only does not work, but also that it produces harmful effects way into the future, way into the necessary conditions for trust in our institutions that we need to have a truly democratic society and institutions that we can trust. But we need to confront that argument. As I said, I think it's a temporary phenomenon, but it's not going to go away given the prevalence of popular culture unless we confront it head on. On a longer-term basis, I think we can see some progress, and we should not let ourselves be depressed by this picture that I am painting to you. Because in terms of international law, and I think international law at least gives us very good tools to combat the prevalence of torture and to abolish torture in practice, even though, of course, by itself it doesn't do the trick. We have in international law over the last 30 years the most detailed and refined normative framework to deal with the phenomenon of torture compared to any other major violation of human rights. Torture has a much more detailed framework that I'm going to describe to you in a minute. But we also have a number of mechanisms and institutions of state responsibility, beginning with the institutions that I already mentioned, but also regional institutions like the European Court for Human Rights, the Inter-American Commission and Inter-American Court of Human Rights that have done an excellent work and that have increasing effectiveness in dealing with the state responsibility for torture. And very significantly, we also have the International Criminal Court for those cases in which states refuse to live up to their obligation to investigate, prosecute, and torture, and punish, torture. But we also have civil society organizations, not only the international ones that I already mentioned, but also very effective civil society organizations working in their own countries, in the trenches, as it were, sometimes under very difficult conditions. But human rights defenders, more so than with other topics, they deal with torture in their own countries and increasingly in a very effective way. So this helps in raising the visibility of the hidden practices that amount to torture or cruel, inhuman, and degrading treatment, and we are beginning to recognize that there are communities and collectivities that suffer torture in special ways, and we need to recognize that. So we do now have a way of understanding the torture that women face in a gender balance perspective, a gender-based approach to torture and to cruel, inhuman, and degrading treatment. We also understand that children suffer the same kind of mechanisms or methodologies in very different ways that demand from us a special kind of protection. So we have the Convention on the Rights of the Child, but we also need to focus on the incidence of juvenile justice detention, because it becomes in many parts of the world a factor that increases the risk that children will be tortured or will be subjected to cruel, inhuman, and degrading treatment. In fact, the report that I am presenting to the United Nations Human Rights Council next month in Geneva is precisely about juvenile detention and the need to revamp and review all of the practices on juvenile justice that rely too much on detention, and because they rely too much on detention and lack of alternatives to detention, end up creating more opportunities for mistreatment and torture of children. I think in the same vein, we recognize the way in which minorities, racial and even sexual minorities, experiment torture. So we do a lot of work on, for example, the special ways in which LGBTI persons are mistreated in detention or in immigration detention, for example. And the rights of persons with disabilities, of course, is now a subject of a special convention that also revolutionizes the legal framework and allows us to look at special practices that we wouldn't or we didn't in the past associate with torture as they apply to persons with disabilities. And one thing that is lagging behind is the whole issue of prisoners' rights. Back in the 50s, we had a much better way in international community to come up with some minimum rules that we should apply to anybody deprived of liberty. And there's a document called the Standard Minimum Rules for the Treatment of Prisoners that is now presently under revision, and that hopefully will be updated, because a document from the 50s obviously doesn't really reflect the realities of detention today. But if we succeed, we're going to get a renewed document that will reflect things like solitary confinement, the need for medical attention in prison, the need for due process in establishing disciplinary processes inside prisons, etc. And that'll go a long way in making, bringing us closer to the abolition of torture. So let me say a little bit about this normative framework that we now have today. I've already mentioned the prohibition of torture and cruel, inhuman, and degrading treatment, and I should say that the differences between the definitions of cruel, inhuman, and degrading treatment and torture are a couple of differences. One, torture has to be intentional, whereas cruel, inhuman, and degrading treatment can happen by negligence. So by definition, conditions of detention that are less than humane, for example, because of overcrowding or because of unsanitary conditions, are by definition cruel, inhuman, and degrading treatment, and not necessarily torture, unless we can determine that somebody wishes that to be the case. But in addition, there's a difference in degree. The torture is a more severe form. There is some need for severity for cruel, inhuman, and degrading treatment, because not everything that causes pain and suffering is automatically either torture or cruel, inhuman, and degrading treatment. But the threshold of severity for cruel, inhuman, and degrading treatment is much lower than the threshold of severity for torture. As I said, the definition of torture requires a specific intent, but some people confuse the specific intent with the purpose of torture. It has nothing to do. The only intent that is required is the deliberate infliction of pain and suffering. If you, whatever other purpose you have for doing it is a separate matter, and it does not deter from the definition of torture. if somebody knowingly inflicts pain and suffering of either a mental or a physical nature, it constitutes torture. In fact, the European Court of Human Rights, in a recent case against France called Selmouni versus France, said that any violence, any force applied on an inmate that is not required by his immediate behavior, that is to contain him, to stop him from harming himself or others, or the guards, is prohibited by the European Convention on Human Rights. And depending on how severe the use of force is, it can constitute torture or cruel, inhuman, and degrading treatment. Then the next feature in the international legal framework is that this prohibition that is absolute, categorical, that doesn't recognize any exception, not any exception for emergency situations or whatever, also triggers a variety of legal effects. One is the obligation to prevent torture from happening in the first place. And the Convention mentions things like training, like civilian and institutional controls over security forces, like reviews of practices, periodical reviews of practices, etc., like visits to prisons and particularly visits by doctors. But the most important feature that the prevention obligation mentions is the obligation to investigate, prosecute, and punish. Because just like in genocide, the normative framework, relies on the fact that if we punish torture, it will act as a deterrent for future cases of torture. Now, we can say that there's no empirical basis for that we really don't know what motivates a torturer to continue torturing, that nobody really thinks, well, my colleague has been punished, so now I shouldn't do that. But the fact is that is the impetus of the normative framework. That's what the drafters of the Convention Against Torture had in mind, like the drafters of the Convention on Genocide. It's maybe an article of faith that if we prosecute and punish, then it won't happen. But I do think it stands to reason that if you make the torturer pay a price for torturing, by being subject at least to prosecution with all the attendant consequences, then it's less likely that he will torture anyway. Or at least the opposite is true. If you make sure that there's impunity for torture, you're only generating the possibility that torture will happen. That, I think, is much more defensible in empirical terms, that torture happens because we look the other way and we let it happen. The obligation to investigate, prosecute, and punish, I think, is the central tenet of the normative framework. And it is both as a preventive measure, but also because it's a moral thing to do, because torture is such a serious crime that decent society cannot tolerate it happening. It is subject to a due diligence standard, so obviously the state has to conduct investigations in good faith, but the fact that it cannot identify somebody who tortured and therefore cannot prosecute him or her doesn't necessarily mean that the state is not living up to its standard. We do have the Protocol of Istanbul, a recent document from 2005, that is a very good guidance as to what is the standard that would prove that the state is engaging in due diligence and is engaging in good faith in discharging this obligation to investigate, prosecute, and punish. And for that, there is an important role for prosecutors and judges, obviously, because they need to initiate ex officio the investigation if there's any evidence or any suspicion that torture may have happened, and they shouldn't rely on the victim carrying the burden of claiming that he or she has been tortured, much less to prove it. Unfortunately, in many parts of the world that I visit, the practice is to put the burden on the victim. many judges and prosecutors tell me, well, we didn't investigate because he never claimed that he had been published, that he had been tortured. Or else I say, well, yeah, he claimed that he didn't prove it. So that, I think, it's very important to strengthen the concept that that torture is a crime that requires ex officio investigations and punishment and prosecution. And obviously this obligation means that there are no amnesties, no pardons, no statutes of limitations, no other obstacles that should stand in the way of the obligation to investigate, prosecute, and punish. Another feature is non-refoulement, the norm by which states are not allowed to send back someone to a place where he or she is at risk of being tortured or subjected to cruel, inhuman, and degrading treatment. This is similar to the non-refoulement provision in refugee law, but it has two differences. One, it's broader in the sense that it protects everybody, not only someone who is entitled to refugee status, because under refugee law, if you've persecuted others, you're not entitled to refugee status, and therefore you can be sent back to a place where you might be persecuted because you persecuted others. But if you're going to be sent back to a place where you're going to be tortured, the Torture Convention says that's an absolute prohibition, and that the entitlement to refugee status has nothing to do with it. On the other hand, it's a little more narrow, because you cannot be sent back to where you're going to be tortured, but it doesn't mean that you're not going to be sent back, say, for example, to a place where you would face persecution more generally, but not torture, or an unfair trial, for example. That would be either covered by refugee law or not covered at all. In this sense, diplomatic assurances, just asking the state that is requiring the person not to torture is completely ineffective. And we've seen many cases, after 9/11 especially, of diplomatic assurances that are not worth any sense. And so, rightly so, my rapporteurship, but also the Committee Against Torture and the Human Rights Committee have denounced this practice of obtaining diplomatic assurances, quote unquote, and then violating the non-refoulement clause of the Torture Convention. There's also the question of the exclusionary rule, that is the rule by which a state is obligated not to use confessions or statements obtained under any form of coercion in proceedings against the person who made the statement. Unfortunately, the formulation in the Convention is defective, because it says that the states are obligated to exclude evidence proven to have been obtained under torture. And that, of course, with what I said before about the attitude of prosecutors and judges, means that a lot of statements that shouldn't be admitted do get in proceedings against the person who made them. So I think it is the burden on the state to prove that all statements are non-coerced, and not the burden of the person to prove that he or she has been tortured. As a practical rule, I always insist on the need to have access to lawyers from the moment of apprehension, and not to be, burdened down on technicalities about whether this is a detention or the detention only happens when you actually take him to the prison, because, of course, in between the privation of liberty and what is technically a detention, a lot of things can happen. And so access to lawyers from the very moment, and the denial of any evidentiary weight to confessions or any other kind of statement obtained without the counsel of lawyers is not necessarily in the Convention Against Torture, but as a matter of a practical approach, we insist on it. And I also obviously think that the international law is beginning to and should adopt the so-called fruit of the poisonous tree doctrine, originally established by the U.S. Supreme Court, but now increasingly adopted by many different states, meaning that not only the confession itself, but any evidence obtained as a result of a coercive practice absolutely loses value and cannot be used in court. The reason is that the objective of that norm is to deter torture. It's not only to have a fair trial, it's also to deter and to provide a disincentive to torture. Whereas if the interrogator thinks that there's going to be some use for the evidence anyway, that produces an incentive to continue torturing. And recently, in the global war on terror, we have seen another worrying phenomenon, that states accept that they can't use the evidence in proceedings against a person, but claim that they can use it for other purposes, like, for example, to share intelligence with other states, or to use it in immigration decisions. And it seems to me that, and again, I wrote a thematic report on the exclusionary rule, in which I argued that if the purpose of the rule is to deter torture, then we ought to close all possibilities of providing an incentive to torture. Because if the evidence or the information or the intelligence obtained under coercion is going to be of some use, that constitutes an incentive for the interrogator or the torturer to engage in it. And there is also the obligation to offer reparations and rehabilitation to victims of torture. What I think is important here is to generate a practice by which the victims are engaged in participating in the design and the execution of programs of reparation, and particularly in programs of rehabilitation for torture victims. But I think access to justice is the most important reparation, that the victim has to have the ability to come to court and to initiate proceedings or prompt the initiation of criminal proceedings, but also civil actions. And this is sustained by another principle of international human rights law, that every violation gives rise to a remedy, as it's called. The state cannot prevent somebody who is a victim of a human rights violation from seeking and having access to justice. And in that sense, for example, the use of state secrets as a means of preventing investigation and even of interfering with civil actions against private perpetrators is a very worrisome development that unfortunately has been supported by the U.S. government in recent years. Let me conclude with just saying that we also need to strengthen the cooperation of states with the special procedures and other mechanisms of international law. We have a lot of problems with being invited to visit countries. Sometimes we are invited and then we are disinvited at the last minute. It happened to me twice with Bahrain, for example. I've been disinvited to Guatemala. I've been disinvited a couple times to Thailand, to Iraq. And the countries generally say, we'll give you another date, but then they don't. And that lack of cooperation is obviously very disruptive, because you prepare in many different ways to go, but also because you postpone other possible visits to other countries, and then you're not accepted. But we also have problems in which, or at least I had one problem, my most recent visit to the Gambia, they have accepted my terms of reference for the visit, and in the middle of the mission they changed it. They did not give me access to a major prison where most of the evidence that we had received alleged that happened there. obviously, if they had said that I was going to be able to visit some prisons but not others, I would have had to decline the invitation. In that same sense, I have countries that we've been asking for an invitation for 25 years, and we don't even get our calls answered anymore. There are many countries like that, even countries that say that they have an open invitation to all special procedures, but when you ask them to put a date on it, they don't, or they don't even answer. In that category, I would say India, for example, is one of them, Iran, Venezuela, Cuba, that just basically ignore our entreaties to be invited. I'm hoping that with Cuba things are going to change now with the renewed diplomatic relations with the United States, but there haven't been any indication that they're going to invite me anytime soon. And then there are countries that invite me, but on conditions that I cannot accept. For example, Russia invites me, but they say all the terms of reference are good. You can go to any prison whenever you want, and even at midnight, and you can visit every part of the prison. But interviews with inmates are subject to ad hoc decisions by the prison authorities or by the investigative authorities in case of pretrial detention. And I can't accept that because obviously, I need to be able to determine with whom I speak, and that I have to be able to speak with people without being monitored. And that's the same problem that I've had with Guantanamo. Back in 2004, my predecessor was invited, but he had to decline because of the conditions offered. And when I became the special rapporteur, and Guantanamo was supposedly a very different place back in 2011, I asked to go to Guantanamo, but I told the State Department and the Defense Department, don't bother to give me the same terms because I can't accept them. And however, a year later, they did invite me, but basically to get a briefing from the authorities of the Guantanamo Bay prison, to visit some parts but not all of the prison, and specifically not to be able to have any conversation with any inmate. So obviously I have declined, but I have declined insisting that they give me an offer that I can accept. And unfortunately, more recently I have asked the United States to invite me to visit state and federal prisons, particularly to look at solitary confinement. And I've been waiting 2 years, and that invitation is still pending. I know that they have to, persuade certain states to invite me, but 2 years is a long time, obviously. And I don't see any reason why the Federal Bureau of Prisons cannot tell me, yes, you can come. I think, as you probably have heard, solitary confinement is a very serious problem in this country, and it does require an objective view of the practice. But there are some good examples, and I have been to countries that initially you would say, they have a serious problem with torture, and perhaps they won't invite me. But not only they have invited me, they've respected the terms of reference, and even though they didn't really like what I had to say, there is a beginning of a dialogue about improving situations in Morocco and Western Sahara, for example, in Mexico, where I visited last year, and even some countries that have allowed me to follow up, like Tajikistan and Tunisia and Uruguay. So I think my final words are on the situation of torture in the United States, and particularly after the publication of the Senate Select Committee on Intelligence report. I think it's a very important step in the right direction, not only to publish the report, because publishing is of course important, but I think it's a very good report. It's a report that is very much in-depth, that is the product of very serious consideration of all kinds of testimonial and documentary evidence, and it engages in this debate about whether the executive branch had misrepresented what had happened or not, not only in Guantanamo, but also in in secret sites and in extraordinary renditions, and in Bagram and Abu Ghraib in Iraq. So it's a hard-hitting, it's an important report. Unfortunately, under the laws that we apply, this truth-telling is an important component, but it's not the only one. So we have all been insisting, after the publication of the report, that the next step is to investigate, prosecute, and punish, and to let the investigations lead wherever they have to lead. Unfortunately, I don't see any sign that this was going to happen anytime soon. But I come from Latin America, and I know that what seems impossible at some point becomes possible at another another moment in the history of a nation. So I think it's important for us to insist on this, if for no other reason, to make it possible that the Senate Select Committee on Intelligence report may one day become the source of the need to do justice to the torture that undoubtedly has happened, and to have the necessary effect of preventing torture from happening in the future. Thank you very much, and I'll be glad to have a good discussion with you.